Thank you, Mr. Chairman. Counselor, congratulations. Help me understand what I'll refer to as the St. Paul's case, the civil litigation. In the civil litigation, what did the plaintiffs allege?
The plaintiffs allege, Senator, that the school failed to protect Miss Prout from being raped by Owen Labrie. Right. The claims were in negligence and breach of fiduciary duty and Title IX.
And what were the plaintiffs asking for in damages?
They were asking for civil damages in the form of monetary relief, Senator.
How much?
Senator, I can't recall specifically if there was a request made at the onset of the case, and I certainly can't speak to the aspects of the case that involve a confidential settlement.
I'm not asking you about the settlement. I'm asking you about the allegations. Were they in the hundreds of thousands, millions?
I don't recall, Senator, and I don't believe that they necessarily would have had to specify that in the complaint when they filed it.
All right. You were in state or federal court?
This was in federal court in the District of New Hampshire, Senator.
Okay. And at some point, you filed a motion with respect to the naming of the minor. Is that right?
That's correct, Senator.
Tell me about that motion.
The family of the minor.
But tell me about the motion first.
So they filed the motion seeking the protection to proceed anonymously.
Oh, so it was their motion.
That's correct. We had the school had an opportunity through its counsel to respond to that motion, and the school agreed to allow the family to proceed anonymously at all pretrial phases of the case, and asked the judge as a condition of that to require the lawyers to try the case in a court of law and not in the media. We, as the lawyers approached the case, the school's perspective was that the request for the lawyers to try the case in the court of law as opposed to the media was fully compatible with the family's request to proceed anonymously and with privacy.
Okay, so I'm just trying to understand. So the plaintiffs filed in the name of Jane Doe. And then the plaintiffs filed a motion. You didn't file a motion. The plaintiffs filed a motion to continue to ask to continue anonymously. Is that right?
That is correct, Senator.
And then the position of the school, you went to your client, St. Paul's, and said, how do you want to respond? And St. Paul's says, we'll agree to that so long as the plaintiff's lawyers don't try this case in the media. Is that correct?
The position the school took was that they would agree to that provided that the lawyers didn't try the case in the media.
Okay. Was that your position or was it your client's position?
That was the school's position, Senator. I was just an advocate advocating for my client as I had a duty to do.
Okay. So that's what your client told you to file this response. You did. I'm assuming that St. Paul's School was getting the hell kicked out of it in the media. I'm not saying justifiably or not. I'm just stating that as a factual matter. And then what happened?
The judge never got to hear the motion that was filed, Senator, because the family that had filed the lawsuit elected to withdraw the motion before the judge could consider it.
And what was the effect of that?
The effect of that was that the motion that was filed became moot and the judge didn't need to address it and never addressed it. What I can say...
And so the plaintiff continued anonymously?
No, at that point, the family elected to proceed without using pseudonyms, Senator.
So the controversy then is about a motion that the plaintiffs filed that you responded to on behalf of your client, and the motion was never resolved, and the plaintiffs then decided to use real names. Is that right?
I believe that's correct, Senator. Again, my role in the case was as an advocate, advancing.
I get it. That's what I'm getting at. I mean, your job's to protect your client.
I had a duty as an officer of the court to advance my client's interests to the best of my ability, Senator.
What if you'd gone to your client? I'm way over. I'm sorry, Mr. Chairman. This will be my last one. If you'd gone to your client and said, look, well, strike that. I think I understand what happened. Thank you, counsel. Thank you, Mr. Chairman. Congratulations to each of you. Judge Gaston, on December 6th, 2008, you wrote, you talked about this with Senator Graham. I'm going to quote, children are not safer because registered sex offenders are prohibited from residing near schools, parks, daycare centers, and other places where children tend to gather. End quote. Did you write that?
I co-wrote that article, yes, sir.
Okay. When you wrote it, did you believe it?
I did.
Okay. All right, let's start back down on this end. Ms. Almadani, tell me about this doctrine of qualified immunity that we're discussing here in Congress and in the newspapers.
Thank you, Senator Kennedy. Qualified immunity applies in 1983 cases as well as Bivens actions to law enforcement officers.
Right.
Unless there is a clearly established constitutional violation, they are subject to qualified immunity. They are immune.
Okay, thank you for that. Let's go to Judge Hunt. Judge, what is the standard? I'm sorry, I keep bumping my mic. What's the standard for granting a motion for summary judgment in federal court?
Thank you for the question, Senator. Summary judgment motions in federal court are evaluated under Federal Rule of Civil Procedure 56. The question is whether there is a genuine issue of material fact that will require a trial. The moving party has the burden of proof of establishing that there is no genuine issue of material fact and that judgment should be granted as a matter of law. If the moving party does not meet that burden, then summary judgment is denied and the case goes forward to trial.
Okay. So basically, it's just, are the facts in dispute and is law in your favor?
That's probably a shorthand for it, but really are there material facts in dispute? Because in my experience, there are often factual disputes, but the question is whether they are material to the resolution of the issue.
Otherwise, you wouldn't be in court.
Exactly.
Judge Hugh, tell me about New York Times v. Sullivan.
I believe that was a First Amendment case, Your Honor. I'm sorry, Senator, and about free speech. But in my 5 years of being a judge and 25 years of practice, I haven't had to actually apply New York Times v. Sullivan.
Okay. Judge, well, I talked to Judge Yassen. Judge Cummings?
Good afternoon, sir.
Good afternoon to you, sir. Tell me the rule that the United States Supreme Court follows in deciding whether to overturn precedent.
Thank you for that question, Senator.
You're welcome.
In deciding to overturn precedent, the court looks at a number of factors, including the soundness of the reasoning of the decision in question, the workability of the rule that it establishes in terms of how it is applied, developments that have taken place since the decision was issued, and they also look at reliance that parties litigants have placed upon that decision in question.
Okay. Let me ask you, well, I'll start back here again. What did the White House give you to prepare for today's hearing?
Senator, there were a number of meetings with the White House counsel's office.
Did they give you any written materials to read?
There were some written materials.
Tell me, what were those?
There were materials that were already in the record, questions and answers from prior hearings.
So they gave you a list of questions and answers from prior hearings?
An overview, I would say.
Yeah. How many questions and answers did they give you?
I'm not sure, Senator. Sitting here, I'm not sure exactly how many questions.
Was it more than 10?
Yes,
More than 50?
I don't believe so.
Okay. And whose questions were they?
They were Senator's questions.
Which ones?
There were some of your questions,
Were
Senator.
there?
But I also watched many hearings, and so I'm.
Thank you, Mr. Chairman.
That's a tribute to you, Senator.
I'm smiling.
Senator Padilla.